This is St. Louis on the Air from St. Louis Public Radio. I'm Elaine Cha.
There are literally tens of millions of dollars available for the expungement process. It was an appeal to racism that got marijuana prohibition passed in the first place.
The prosecutors and judges all sort of had to get together and sign hundreds of these things in a matter of a couple weeks or two. So it was a big change, and everybody's talking about it.
When Missouri voters passed a constitutional amendment in November to make recreational marijuana legal for adults 21 and over, one of its key conditions and selling points to voters was expunging cannabis convictions from people's records. Missouri courts had a June 8th deadline to do that. It's now June 20th, and while tens of thousands of marijuana-related convictions have been wiped away, many more remain. Joining me to discuss the status of expungements across the state and where that effort has come up short, we welcome Dan Viets, attorney and Missouri coordinator for the National Organization for the Reform of Marijuana Laws, or NORML. Dan, welcome to the show.
Thank you, Elaine.
Now, you've had a direct role in crafting the ballot measure that became Article 14 of Missouri's Constitution. Tell us a bit about what went into the final proposal around expunging people's records.
As you've noted, there was a June 8 deadline to expunge misdemeanor cases in Missouri courts. We were cognizant of the fact that that would be a tall order, that it would be difficult to wipe out nearly 100 years' worth of misdemeanor convictions by the 8th day of June. But what we've always said is that as long as the counties are making a good faith effort to comply with the Missouri Constitution, we would be satisfied, and assuming that effort continues. It is clear that many counties have made that good faith effort, but there are many others who have not.
Mm-hmm. Now, insofar as the cases that you were targeting, and you were talking about misdemeanors, Missouri law makes most marijuana crimes a misdemeanor, but there are cases when it can be a felony. Can you tell me how you navigated those definitions as you were crafting the language?
Well, there are many, many felony offenses involving marijuana under Missouri law. The possession of any more than 1 1/4 ounces is a felony offense. Even the attempt to cultivate a single marijuana plant is a felony offense. Mm-hmm. There are many, many felonies involving marijuana under Missouri law. I would agree that the majority of the offenses are misdemeanors because there are many more people who consume relatively small amounts than there are people who cultivate or possess larger amounts. We've given the state until December the 8th to expunge the felony offenses.
These courts, you mentioned, as I did, that June 8th deadline, and that was a total of 6 months from the time that the law went into effect and that the courts needed to start moving. How many of the courts met the June 8th deadline?
I'm not sure any of them were actually able to expunge, again, nearly 100 years worth of misdemeanor offenses. But there are many counties across the state who are clearly making a good faith effort to do that. Mm-hmm. As of the 1st of June, Buchanan County up in St. Joseph was the leading county in the state with more than 2,000 expungements. There are several counties that have more than 1,000 expungements. But again, there are many generally rural counties who don't seem to be making any effort whatsoever.
Mm-hmm. And when it comes to the number of courts, what's the number that we're looking at?
Well, there are 114 counties plus the city of St. Louis.
So 115 altogether.
Yes.
And as you've noted, 100 years of charges, that is a lot to work with. Now, do the courts have the resources they need to make a dent in those 100 years of cases?
They should have, Elaine, because one of the things we wrote into Article 14 of the Missouri Constitution, along with the mandate to expunge marijuana cases, is that it is a priority for the use of the 6% sales tax on marijuana statewide. The very first use of that money is to pay for the expungements. That is to pay for the additional staff, the overtime, or the additional temporary workers that are needed. The Missouri legislature has appropriated that money. They made a supplemental appropriation in January, and they added several $1,000,000 to the 2024 budget that they passed just last month.
So money then should not be the reason these expungements are not happening.
It should not be. That's true. Now, if you talk to the clerks themselves, they may say that they're having problems accessing that money. I don't know, frankly, if that's the issue or not. But with projected sales of approximately $1 billion this year, there are literally tens of millions of dollars available for the expungement process.
And that's money that continues to come in. When we're talking about St. Louis City and St. Louis County, how have expungements gone there or where we are?
Well, again, as of the beginning of June, according to the data that I have obtained, St. Louis County had expunged nearly 1,000 cases. The city of St. Louis, however, has only expunged approximately 200. Now, again, that was a few weeks ago. I'm sure the numbers are somewhat larger now. But the city of St. Louis is not making a very good effort, frankly. There should be many more cases already expunged in the city of St. Louis.
And does that have anything to do with the way that in St. Louis City that they've decided not to pursue charges against people for marijuana, or is that kind of besides the point?
I doubt it. Again, we're talking about a century of marijuana prosecutions. I have no doubt that there are many thousands of marijuana cases that were prosecuted in the city of St. Louis before that more enlightened policy came into effect.
Now, last week we checked in with Matt Schmidt, and Matt is a public defender in Scott County, which is one of the counties that expunged more than 1,000 cases.
Both of the counties that I've worked in recently, I think, met the deadline. I was in a situation a couple of weeks ago where we were just waiting in court, and so prosecutors and the judge and I were, just chit-chatting, and a judge made a joke. He had his hand was cramping up because he'd recently signed all these expungements. Like, these counties are aware of the deadline, so the prosecutors and judges all sort of had to get together and sign hundreds of these things in a matter of a couple of weeks or two. So it was a big change, and everybody's talking about it.
So, Dan, is that consistent with what you've heard?
Well, I'm glad that the judge is making that effort, cramps notwithstanding. It's very important that people receive the relief that the people of Missouri mandated they should receive when they passed Article 14 in November of last year. So, Scott County, a relatively small county, has expunged about 1,000 cases at this point. I think that does indicate that they're making a good faith effort. But again, there are many primarily rural counties that are not making a good faith effort, that are making little or no effort.
Mm-hmm. And these rural counties, is this chalked up to the lack of capacity that they have? Is there anything that these counties have in common?
Not that I can see. No, many rural counties are, in fact, making a good effort and expunging hundreds of cases, and we expect they will continue to do so. But, there's no reason that I'm aware of that would explain expunging no cases. There are about a half dozen counties which have not expunged a single marijuana case in the past 6 months. There are many other counties that have expunged a token amount, not to make a play on words, but a very small amount of 10 or fewer. So, there's just no rational explanation for that, except that they're not making an effort.
Mm-hmm. We need to take a quick break, but we'll be back shortly to continue this conversation about the state of cannabis-related expungements in Missouri. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. Let's return to our conversation about the status of cannabis expungements, which we're discussing with Dan Viets. Dan is an attorney and the Missouri coordinator for the National Organization for the Reform of Marijuana Laws, or NORML. Dan, before the break, we were talking about places where expungements are not happening. Some of them are in rural counties, others are not. In a statement earlier this month, after that June 8th deadline passed, you said there's no reason why these counties should be dragging their feet, and added that there could be further legal action to make those counties get their act together. Dan, what would that sort of court order seek, and against whom?
Well, one possibility, and we have not settled on a specific course of action, but one possibility would be to seek what's called a writ of mandamus, a court order which instructs public officials to follow the law. And so, of course, we would at least consider seeking a court order, possibly from the Missouri Supreme Court, addressed to the individual counties and instructing them to abide by the law, instructing them to abide by, in fact, the Missouri Constitution, which now mandates that these expungements go forward.
And is there precedent for that approach in other states that have been slow to expunge when they were supposed to?
Frankly, Missouri is on the cutting edge in this matter. I'm not aware of very many other states which have mandated expungements as part of a legalization initiative. I know that there are expungement efforts taking place across the country. I'm not aware of any in which a court order was required in order to get local officials to comply.
And from your perspective, do you think that the expungement component was what made passing the constitutional change or amendment about marijuana more attractive to people?
Well, for some people, yes, but for others, no. It is something that we believed was very important. We wanted to not only stop the disruption of people's lives with marijuana prosecutions, arrests, in some cases imprisonment, in many cases probation. We wanted to stop that from happening, but we also wanted to try to undo the damage that marijuana prohibition has done during the past 100 years. And so the best way to do that is to wipe out these cases, not only convictions, but cases that did not result in a true conviction. Missouri often disposes, especially of first offense, small amount possession cases, with what's called a suspended imposition of sentence, an SIS probation. And technically, that does not result in a conviction. It does result in a term of probation. If that probation is successfully completed, the defendant does not have a conviction, and there's no public record of the case. It's still very important that those be expunged. And so many counties are indeed proceeding with expungement of even the SIS probation cases, but other counties are failing to do so.
Right. Now, the new expungement rules have had its critics. And Stephen Sokoloff, who is the senior counsel for the Missouri Association of Prosecuting Attorneys, told KCUR that the June 8th deadline was never realistic. And he pointed to what he described as a disconnect between what the amendment demanded and what Missouri allows. So I heard you laugh there. Does Sokoloff have a point, Dan?
Well, first off, prosecutors have no role in this process. I mean, they can raise an objection, I suppose, if they want to, but they have no role directly in the expungement process, and I think some of them resent that fact. I acknowledge also that, again, with about a century of marijuana prohibition, undoing all of those cases, those misdemeanor cases within 6 months, the felony cases within a year, is a tall order. And that's why we have consistently said that we will be very tolerant and understanding of counties that are making a good faith effort, but the counties that are clearly making little or no effort whatsoever, they apparently need some encouragement. And one option that we're pursuing is to seek a writ of mandamus, a court order requiring them to abide by the Constitution. After all, public officials, including every lawyer in the state of Missouri, take an oath to uphold the Missouri Constitution. They shouldn't require a court order to do what they've sworn to do.
Right.
But if that's what's required, we will pursue it. And if they continue then to fail, they will be in contempt of court.
Now, before the break, Dan, we had heard you talking about some of the places where there have been more expungements, where I think you'd mentioned St. Joseph County is one of those.
Buchanan, yes.
Buchanan County.
The county seat is in St. Joseph.
And we mentioned Matt Schmidt earlier, who is that public defender, and he's in Scott County, which is about a 2-hour drive south of St. Louis. Matt has been working on getting his clients' cases expunged, and he told us that he's not surprised that some Missouri counties have missed the deadline. And he says that's because the state's court system is just not built for this sort of challenge.
Looking inside the system, it's not set up to do this. The charge codes for a variety of marijuana-related offenses don't always reflect marijuana. It's not like you could do a search on the big criminal database in the state of Missouri for marijuana and get everybody. Things would be charged as distribution of a controlled substance, possession of a controlled substance, paraphernalia, and all those things. The court clerks are going to have to search for everything that could conceivably have been a marijuana charge, and then go through and read the original police reports and see what's in there. It may not even have been possible in all cases for the clerk to figure out what was actually at stake, given that the rules for expungement that are contained in the amendment aren't the same rules that put people in jail. So they're having to just sort of match up different things. And it was, in a lot of these cases, in their smaller counties, your files are paper. So there's not even a database to search. You're talking about somebody going through the archives and just having to eyeball them all. So it's just a lot of time, and the system wasn't set up for it. And nobody was particularly motivated, right? Like, this wasn't the courts petitioning to be able to do this. This is something that they were told to do by the voters. And people always drag their feet when they're, told to do something like that.
That was Matt Schmidt, a public defender who is working down in Scott County. Dan, what do you make of what Matt shared there? I mean, is this a problem with the court systems, its record keeping, the people inside?
All of those things. It is indeed a big job. It's a job that the voters of Missouri have ordered our courts to do. Primarily, the burden falls on the circuit court clerk's offices, but the judges share responsibility for it. I have little sympathy for those who say, we just don't have time, we don't have the resources, because for 100 years, they've been putting our clients in jail or in prison or at least on probation if they're lucky. So undoing that damage should be a high priority. The people of our state have told our courts to do it. It's part of our Constitution. And we've given them the money to do it. That's why there's really no good excuse for not doing it, for not getting these expungements done. We have a projected $1 billion in marijuana sales this year alone. That means there will be tens of millions of dollars, somewhere between $40 and $60 million available to pay for the additional staff, the overtime, however the clerks choose to approach this. But doing nothing is not an option. And if they need an incentive, if they need encouragement, we're going to ask the courts, the appellate courts in our state, to provide that incentive to them.
And what is it that you are seeing from prosecutors and judges? Are they backing these new laws or holding them up?
Some judges and prosecutors are being true to the Constitution, and many are not. Many are looking for excuses to avoid complying with the law. The fundamental issue is getting these expungements moving, but there are some technical issues that people have come up with that have no support at all in the law. There are some courts that are saying, an SIS probation is not a conviction, so we can't expunge that. Well, that's ridiculous. SISs have been expunged for many years. in particular in regard to DWI cases. There are some courts that are saying, well, THC is not the same thing as marijuana. So if someone's convicted of possession of tetrahydrocannabinol, then we don't have to expunge that. And that's wrong. It's clearly wrong. The definition of marijuana is very broad and clearly encompasses tetrahydrocannabinol. There are other excuses that some prosecutors and some judges have come up with to try to reduce the number of cases that are eligible for expungement. And again, we will go to court if we have to in order to resolve those questions.
Now, an attorney with the Clear My Record project in Kansas City reported one particular case about someone named Adrian, who was arrested in 2018 for possession. Then when Amendment 3 passed, Adrian was excited for his records to be expunged. Instead, though, he was told that he wasn't eligible because the amount of weed he had at the time of arrest wasn't specified in the police report. How common a problem is this?
Not terribly common. It's a little bit complex. The weight of marijuana involved is relevant if you're trying to get off probation or get out of prison early. There is a specific weight limit. However, regarding general expungement, weight has nothing to do with it. All misdemeanor marijuana offenses, all felony marijuana offenses, regardless of weight, are to be expunged. Early release requires that your case involved 3 pounds or less. But other than the people who are currently on probation or currently incarcerated, weight has nothing to do with it.
We're talking today about cannabis expungements. In Missouri, courts have processed more than 40,000 expungements, and we're discussing the impact of that change with Dan Viets. Dan is an attorney and the Missouri coordinator for the National Organization for the Reform of Marijuana Laws, or NORML. Now, Dan, this requirement for the courts to expunge records of people with cannabis convictions, this also applies to people in prison. Are people being freed from prison through this kind of expungement?
Some people are. There are at least a small number of people who were in prison and who were there on charges involving 3 pounds or less of marijuana, but not a great number. There are far more people who were on probation, and they too are eligible for immediate release from probation or from parole if their offense involved less than 3 pounds. But again, the expungements generally, weight is not an issue. It's either a misdemeanor and should have been expunged by June 8, or it's a felony offense, meaning it should be expunged by the 8th of December this year.
Mm-hmm. Now, Dan, you've been doing this work for quite some time. What is it about this work that is important to you?
Many things are important, but I can tell you that the roots of marijuana prohibition are deep in racism. People who go back and look at the media coverage around the issue 100 years ago are struck by the fact that so often the horror stories that were promoted by police and by prosecutors and by willing media reporters sensationalized the racist aspects of marijuana prohibition. It was portrayed as something that was used by black people and by Mexicans, and it was an appeal to racism that got marijuana prohibition passed in the first place. That racism continues to be seen today in the fact that there are 2.6 times as many African Americans prosecuted for marijuana, arrested, prosecuted, and in many cases imprisoned, as there are European Americans, taking into account their proportion of the population. 2.6 times more African Americans are prosecuted for marijuana in Missouri. Mm-hmm. We need to put a stop to that. That's what Article 14 does. It stopped any more of these arrests. The expungement is especially important to African Americans because they represent 2.6 times more of the victims of prohibition. Marijuana prohibition never made any sense. It was always based on irrational fears. The courts are, to a large degree, responsible for maintaining that racist policy. We need to undo the damage that marijuana prohibition did to people. You know, came to college in the late 60s, early 70s. That was the first time I was exposed to people using marijuana. I was immediately struck by the fact that we're making criminals out of people who are harming no one,
Right.
probably not even themselves. But it never made sense to treat marijuana as a criminal matter. It has always made much more sense to regulate marijuana use, limit it to adults, place reasonable limitations on its use, not allow people to drive if they're truly impaired by marijuana use. But treating everyone who uses marijuana like a criminal is insane. And I have done this for 37 years. I've been representing people charged with marijuana offenses. The vast majority of those people are solid, good, intelligent, responsible citizens. They do not deserve to be lumped in with people who have committed horrible crimes. But
Right.
that's exactly the way the state of Missouri has treated marijuana consumers for about 100 years.
Yeah.
We've put a stop to that, and we're now engaged in undoing that damage.
Now, to wrap up, everything we've spoken about, Dan, it deals with state level action and state level crimes. What could change, do you think, if these reforms reach the federal level?
Well, that's already begun. President Biden declared late last year that he was issuing presidential pardons to people convicted of very low-level federal marijuana offenses. That will affect some people in Missouri. People who are caught on federal parkland or national waterways may indeed have a federal marijuana conviction for small amounts, and those pardons are forthcoming. More significantly, the Biden administration is examining the question of rescheduling marijuana. Now, frankly, NORML believes that they should deschedule marijuana. Just like alcohol and tobacco, they're not on the federal or state schedules of controlled substances. Marijuana should not appear on those either. However, the road to the repeal of federal prohibition is long, and it's a shame it's taking this long. We've now got 23 states that have legalized adult use of marijuana. Around 38 states have legalized medical use of marijuana. The federal government needs to act. And frankly, the best policy would be for the federal government to simply get out of the marijuana business. They have no need to be involved. Let the states administer marijuana policy.
Dan Viets is an attorney and Missouri coordinator for the National Organization for the Reform of Marijuana Laws, or NORML. Dan, thank you so much for talking with us today.
Thank you, Elaine, very much.
Today's episode was produced and edited by Danny Wissentowski and engineered by Maya Norfleet. Live engineering, podcast design, and production assistance by Aaron Dorr. Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Our podcast proudly supports St. Louis artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.